Good morning, everyone. How are you this morning? We are here to present part 2 of the divorce and custody nuts and bolts. Some of you may have not been on were not on the original program, part 1. For those who weren't, I'm going to do another introduction of our speakers because we're very happy to have them. First of all, I want to introduce Jack Condliffe. Jack Condliffe is a principal for Levin Gann P.A. I believe you joined them. You've probably been with them longer than it says here. You were a principal as of 2011. Is that correct, Jack?
Yeah, that was I switched after my wife retired.
I see. His practice includes family law and adoption, complex personal injury cases, estate litigation, and appellate law. Mr. Condliffe has received numerous prestigious awards for his service to Marylanders and to the Maryland courts, including the 2020 Judge Robert M. Bell Maryland Pro Bono Service Award from the Pro Bono Research Center and Maryland State Bar Maryland State Bar. He also received the Exceptional Service Award in 2019 from the judges of the United States District Court of Maryland and the Leadership in Law Award from the Maryland Daily Record in 2013. An acknowledged leader in the law, Mr. Condliffe served as president of the board of the Pro Bono Resource Center of Maryland for 2 years and a board member for 10 years. He also served as a governor of the Maryland Association of Justice for 8 years. You all may know Mr. Condliffe as a co-editor and author of the alimony chapter of the Maryland Divorce and Separation Law published by the Maryland State Bar Association. He has published a number of articles and has lectured widely. He is recognized as a Maryland super lawyer each year from 2010 to date, as well as being one of Maryland's top 100 lawyers in 2020. In addition to his successful private practice, Mr. Condliffe does individual pro bono cases. Mostly those have been on behalf of the Sexual Assault Legal Institute, Legal Aid of Maryland, and Catholic Charities of Washington, D.C. Mr. Condliffe has won many appellate cases that have changed Maryland law, including Bozeman v. Bozeman, abrogating spousal immunity, Aronson v. Arison, the standard for voluntary and mutual grounds for divorce, and Volodarsky versus Tanachaniskaya. I don't know if I pronounced that correctly, but I'll put it in the chat later. Establishing the standard of evidence for abuse-based visitation restrictions, and nearly two dozen other published appellate decisions. He received his JD from the University of Maryland in 1991 after service in the Peace Corps, and he received his bachelor's from the University of Oregon in 1978, one of my favorite states. We also have with us today Shannon Boisseau, correct?
Yes, it is. Thank you.
Thank you. As a part of Levin Gann P.A. since 2018, concentrating primarily on matters of family law and general litigation. Prior to joining Levin Gann, Ms. Boisseau served as a judicial law clerk to the Honorable Michael J. Finneter in the Circuit Court for Baltimore County, where she gained a unique perspective on a variety of complex matters as it relates to civil and domestic disputes, and identified invaluable strategies that have helped her refine her practice. Ms. Boisseau has had the pleasure and distinct honor to represent clients in front of Maryland Supreme Court and the Appellate Court of Maryland on matters of first impression, and this is very impressive, and has been successful in establishing law as it pertains to Maryland's approach in determining the disposition of cryogenically frozen pre-embryos upon the dissolution of a party's marriage or partnership, and this was decided in Jocelyn P. versus Joshua P. Ms. Boisseau graduated Duquesne University with a BA in political science and a minor in psychology. Prior to and while attending law school as a part-time evening student, Ms. Boisseau was employed by the University of Maryland's Baltimore Office of Research and Development, where she was responsible for negotiating industry-sponsored clinical trial and corporate contract agreements for the university's schools of medicine, dentistry, and pharmacy. Ms. Boisseau earned her Juris Doctorate from the University of Baltimore School of Law in 2017, graduating magna cum laude. In 2017, she was admitted to the Maryland Bar. She was selected as a Super Lawyers Maryland Rising Star for each successive year since 2020. And I might also add that Ms. Boisseau is also an author of the Maryland Separation and Divorce Law publication that we keep on our desks always, and particularly in the matter of custody and those areas. I thank you so much, both of you, for being here today, and we will proceed.
Well, thank you, Nancy. Appreciate that introduction. So today we will pick up talking about custody, and specifically talking about de facto parents and third-party custody. Now, obviously, we are talking about custody and visitation rights of persons who are not the legal parents, biological or adoptive parents. So what is a de facto parent? Well, a de facto parent is generally any person with whom a child has developed a particularly close relationship. Anybody can be a de facto parent. It is not restricted to any particular categories of people, such as grandparents, aunts, uncles, other blood relatives, but they must meet the following criteria. The legal parent consents to and fosters the relationship between the third party and the child. The third party must have lived with the child. Typically, this would be for a sustained period of time. We're looking anywhere around somewhere over a year or more. The third party must also perform parental functions to the child to a significant degree, i.e. they take on the responsibilities of a legal parent. They take the child to school, they feed the child, they go through the routines that a normal parent would go through on a day-to-day basis. They are making important decisions for the child, taking them to the doctors, medical appointments, etc. And most importantly, the parent-child bond must be formed. Now, if a third party can meet the factors of a de facto parent, that relationship may entitle the third party to seek custody and or visitation with the child. And I should mention that the burden of proof is by clear and convincing evidence, meaning greater than a preponderance of the evidence, more than 50-50, more likely than not, but not any more, not less than, less than beyond a reasonable doubt. So we're looking somewhere around the 70% certainty mark. But of course, we don't stop there. In evaluating whether the de facto parent may be entitled to custody and or visitation, the court still does look to the best interests of the child standard. It is no longer the singular and controlling factor, looking to the other factors that I just mentioned. Now, this is different from other third-party custody where the third party is not a de facto parent, which we will talk about shortly, because in those cases where there is not a de facto parent relationship, the court does not even reach the best interests of the child standard unless certain thresholds are met. And importantly, there cannot be a de facto parent if there are already two natural parents. So we can't have three parents. For example, in a more recent case, decided by Maryland Supreme Court, which is ENVTR 474 MD 346, decided in 2021, the court held that if a child has two legal parents, the putative de facto parent must demonstrate that both legal parents consented to and fostered such relationship, or that a non-consenting legal parent is either unfit or exceptional circumstances exist, which we'll talk about in a moment, under the regular third-party access requirements. Now, this holding actually overturned the appellate's court finding that in the same case, TR was a de facto parent, having primarily resided with the children for the past 3 years, when even though the father authorized TR to have full custody of his 2 children, mother did not consent to TR having custody. Now, you may be familiar with the case Conover v. Conover for 50 MD 151, in 2016. That's perhaps one of the more well-known cases on third-party access, which overruled Janice M. v. Margaret K. And this is actually the case that recognized the legal status of the de facto parent in Maryland. The circumstances of that case were actually that a same-sex couple, wherein the non-biological parent sued for custody of the child, Jackson, conceived by the biological parent, the other party in the case, through the use of a sperm donor, 6 months prior to their marriage. And the court actually held that Michelle, the non-biological parent, was a de facto parent, having discussed with Brittany, the biological parent, the desire to conceive a child through the use of a sperm donor, and having raised Jackson as her own. Ordinarily, under Maryland's rules, Michelle would not have been able to exercise custody or visitation of the child unless she could prove that Brittany, was either unfit or exceptional circumstances were in play. But again, the court decided that because Michelle was in fact instrumental in the raising of the child, it was the party's decision to have the child. She was in fact a de facto parent and entitled to legal rights as a parent in this case. Now, switching gears a little bit, if a third party is not a de facto parent, the court requires a showing of either parental unfitness or extraordinary circumstances. And that is before the best interests of the child will even be considered. As an example, when we're talking about unfitness, we're typically talking about instances of neglect, abuse, abandonment. In an unreported opinion, for example purposes, Doherty v. Doherty, a court placed mother's 4 children in the care of paternal grandparents after finding mother unfit. The circumstances of that case were that the children were suffering from breathing problems caused by mother's heavy smoking around them. They were severely undernourished. Testimony revealed that the children were seen eating off the floor, out of the trash. They weren't eating really anything other than dry cereal. So those are types of circumstances that the court would look for when we are talking about unfitness of a parent. And as far as exceptional circumstances, the court has declined to really define what you may hear as either extraordinary or exceptional circumstances, but generally it considers certain factors. It considers the length of time that the child has been away from the biological parent. Again, if a third party has been exercising custody for at least a year or more, they're more likely to win custody. The age of the child when care was assumed by the third party. This would be something like if a party that, one moment, I just lost my screen. This would be something like if a party assumes custody of a child at a young age, they may be more likely to assume custody going forward, provided that it has continued for a sufficient period of time. We're thinking of grandparents raising grandchildren for a young age. The possible emotional connection of the child on a change of custody, How closely is that child bonded to the parents and the third party? The courts will also look to the period of time elapsed before the parent has sought to reclaim the child. How long has it been since the parent has neglected responsibilities for the child? What are those reasons? This would be something that we would think in terms of parents attending and successfully completing rehab. Are they coming back? Are they looking to seek care and custody of their child now that they are well? The court will look to the nature and strength of ties between the child and the third party. Again, what does that relationship look like with the third party? Keep in mind that if the child does view the third party as a parent, the child lives with the third party, and the legal parents have consented and encouraged that relationship, we might actually be in de facto parenthood land. So that's something to think about. There is often an overlap. It is kind of a sliding scale when we're talking about third-party custody. If you can meet that de facto parenthood standard, then you don't have to prove unfitness or exceptional circumstances. The court will also look to the genuineness of a party's desire to have the child. They consider the motives of the parties involved. And of course, they consider the stability and certainty as to the child's future with the parent. How stable is the parent now? What does stability look like in the future? And you will actually find all of these factors set forth in Allmiller v. Allmiller, and that's at 183 MD App 71. It's a 2008 case, and Jack, I believe this was actually your case that you argued. And in this case, the grandparents were granted access with their grandchildren at the trial court level over mom's objection. The dad was deceased. And during mom's appeal, Maryland Supreme Court actually handed down Koshko v. Haining, which stood for the present standard that the court must first make a finding of either unfitness or extraordinary circumstances before considering the best interests of the child standard. So the case was then remanded. The trial court, found that the grandparents did not make a prima facie case of extraordinary circumstances, and the appellate court affirmed that decision.
Let me just add a little color here, Shannon.
Absolutely.
So in Allmiller, the grandparents actually had literally no relationship with the two children that were at issue. Their son had died of a drug overdose. During the time when the Allmillers were married, the grandparents had seen the children maybe once or twice over a 6-year period for no more than a couple of hours. So it wasn't as if they were babysitting. The kids weren't seeing the grandparents, every other week. There was just literally no contact. In fact, the father had been in jail for some period of time. After he got out of jail, wife took him back on the theory that he had kicked his drug habit. He had not. She threw him out a second time. As background in this case, the particular judge who made the first ruling granting grandparent visitation, even though the grandparents had been completely uninvolved, I'll just say was a member of the court who frowned on single mothers. I really never understood why, but I'd had numerous cases in front of her. Her attitude was always the same about single mothers. And Miss Allmiller at the first trial, I think, from the judge's perspective, didn't make a good presentation. She had multiple piercings, tattoos, and the judge clearly did not care for her. Interestingly, the second decision by the judge not allowing access to the grandparents was also appealed. There was an unpublished opinion, but the argument that was made by the grandparents' lawyer, who was very good, was interesting. She argued that in the case of grandparents, that the court should establish some mechanism so that even though they had no relationship before, there needed to be a mechanism, either therapy or something that would allow them to get to a place where they could establish a relationship. And in the unpublished opinion, the appellate court rejected that argument. During this case, by the way, Ms. Allmiller was in constant contact with Doherty from the other case. She was constantly talking to me about her conversations with the mother in that case. But the bottom line was that the grandparents actually behaved quite badly. They blamed the mother for their son's drug overdose. They showed up at the children's school unannounced without telling the mother, so that one day the kid just walked home from school and said, Mommy, I just met my grandmother. And as you might imagine, Miss Allmiller was quite upset by that happening, really quite shocked, and had to contact the school and tell them, they really should have contacted her first and gotten her consent, which they did. They just assumed that because it was a grandmother, of course she can visit. So, that case was a relatively simple one. And I think it was a published opinion because it was a very good example of, if the third party, the grandparents, have no relationship, no, the courts can't order access, irrespective of the fact that we have a grandparent visitation statute that's still on the books. So, so that case was went on for quite some time before it was finally over. So that's it on that case.
Jack, could you repeat? We have a question. They would like
Sure.
to cite for Allmiller.
Yeah, sure. I think we have it.
I have it right here, Nancy.
Yeah.
It's 183 MD App 71. It's
Right.
2008.
It's a very, very short opinion. I'm not sure it's more than 6 or 8 pages long. I'm just going to add one other thing, that the most recent opinion on de facto custody, where it said that there were certain circumstances where there could be a third parent, actually reversed a part of the original de facto case that said that there couldn't be a third parent. And that case allowing a third parent really starts to blur the lines between de facto parenthood and the third-party custody, something about which the minority, what was the name of the first one? It wasn't Conover, was it? Yeah.
Conover.
Yeah, the Conover case. I mean, if you read Conover, there is a very vocal concurring opinion talking about the dangers of establishing a precedent where there can be 3 parents. But eventually the court threw in the towel on that because, quite frankly, there are situations where step-parent can become so important in a child's life, there are effectively 3 parents. So something with which I'm personally familiar, because in my stepkids, there was also a stepmother, and they were all 4 and very involved as parents. So, it sort of reflects reality, but could get pretty tortured in the case law.
Definitely. So then as far as just the standards, remember that the bar is high because courts are not exactly willing to get involved between disputes, with disputes between parents and particularly grandparents, but any other third parties, over whether or not there should be visitation and how often. To the extent that parents are fit, there is a lack of exceptional circumstances, courts generally defer to parents' wishes in accordance with the parents' constitutional rights to raise the children how they see fit. And this is exactly what the due process clause protects. It does not permit a state to infringe upon the fundamental rights of parents to make child rearing decisions simply because a state or a judge believes that a better decision for the child could be made. That's why we have to first establish that there is unfitness or exceptional circumstances before the court can even reach the best interests of the child standard. Supreme Court of Maryland, on many opinions, has articulated and applied the very same principles confirmed in Troxel. And that is, essentially a state is only permitted to interfere with a parent's rights to rear his or her child only to prevent harm or potential harm to the child. And determination that a grandparent visitation is in the best interest of the child is an overstep. So that's something just to keep in mind when you are going through these types of cases as to why those are the standards. And again, the burden here is just like in de facto parent, clear and convincing evidence. Some examples from recent cases surrounding third-party access or custody. In Trenton v. Christ, although the biological parent was not unfit, his 10-year-old daughter's preference to stay in Maryland with her grandparents rather than move to Wisconsin with him, her father, was considered as an exceptional circumstance sufficient to overcome the parental presumption. In Dietrich v. Anderson, the foster parents were awarded custody of a child who had been in their care for 5 years. Father had claimed an inability to care for the child and actually left the child to the care of the foster parents. Claims asserting exceptional circumstances and parental unfitness, which fail to allege sufficient factual predicate, will be denied. It is not simply enough to present a prima facie case of unfitness or exceptional circumstances by claiming unfitness based on alleged observations of the child, the fact that parents ignore the child's concerns. You need to be very specific. These cases are very factually specific. And where a party's concerns are trivial in nature and they fail to provide any basis, a claim again will be denied. In McDermott v. Doherty, another case that held in disputed custody cases where private third parties are attempting to gain custody of children from natural parents, the trial court must first find that both natural parents are unfit to have custody or that extraordinary circumstances exist, which are significantly detrimental to the child remaining in the custody of the parent or parents. Again, before the court can consider the best interest of the child standard as a means of determining custody and or visitation. In this case, McDermott, while the court found that the natural mother was unfit, the court determined that there were no exceptional circumstances present that would warrant an award of custody to the grandparents, finding that the requirements of the father's employment, such that he was required to be away at sea or otherwise absent from the state for a period of time, for which he actually had made appropriate arrangements for the care of the children, did not constitute exceptional or extraordinary circumstances as it pertained to the father to support awarding custody of the children to the grandparents. So again, it is both unfitness and exceptional circumstances, and you have to find those for each parent. Otherwise, the court will defer to custody remaining with the fit parent or the legal parent. If the third party is successful in showing unfitness or exceptional circumstances, it must also prove that there will be current or future detriment to the child, absent that third party visitation and or custody. Harm may not be presumed by the court, it has to be proved. So keep in mind that it is error for the trial court to grant visitation to a third party over a fit party's objection without finding unfitness or exceptional circumstances as it relates to that parent. Also have to keep in mind that any motion to establish third party visitation rights both parties are necessary parties to that case.
Let me just add a couple things about
Yeah.
McDermott. So McDermott was actually the first case that really delved into this issue of third-party custody. I actually think the mother might have passed away, not that she was unfit, but I'd have to go back and look at the case. But in any event, the father was a merchant marine. He was at sea 6 months a year. And the circuit court simply felt that that was going to contribute to a lack of stability for the children and granted custody to the grandparents. When McDermott first came out, it caused a lot of concern because the definition they gave of exceptional circumstances seemed very strict, and the initial reaction a lot of people had was it would virtually mean that there would never be third-party custody absent serious unfitness on the part of a parent, and exceptional circumstances was defined pretty harshly. The Trenton case is a great example where the appellate court sort of backed off on that and gave the judges of the state a lot more flexibility in defining exceptional circumstances. Then another case that came up after that was Koshko versus Haining, because McDermott also suggested the possibility of a different standard between seeking custody and seeking visitation. Koshko is really, really important because it's the first case that finally makes clear that visitation is simply a lesser form of custody. And that is one of the really crucial distinctions that I think most people are familiar with now. But at the time of the decision, judges were constantly trying to figure out what the difference between those two was, as were lawyers. And so, judges started taking a slightly more liberal look at exceptional circumstances. A lot of these cases arise out of the death of a parent, where suddenly one parent doesn't like the deceased spouse's parents and they're cut off. Whether or not those grandparents can gain access really depends on the bond between the grandparents and the child. If these grandparents babysat the child, every weekend for 6 years, I think most judges are going to find that that's an exceptional circumstance. They may not order access every weekend like the grandparents were having in the past. In the one case I had like this, Judge Martin gave my clients visitation once a month on the weekend and then a week in the summer to maintain their contact with the child. That was actually over the opposition of both parents, and there were some drug issues in that case. So what you have to recognize about exceptional circumstances is it's one of those standards that is highly judge dependent. It really depends what judge you're in front of in terms of what that means. So that's sort of just a little bit about McDermott.
And just to follow up on kind of what Jack was saying regarding visitation and custody, that's what we touched on last time, is courts are really trending away from the terms of visitation and custody and more so access, because they have been grappling with what is the difference between those two terms. So when we're talking about visitation and custody, we do tend to talk about access to the child. Here, I'm just using visitation and custody as in terms of one being a little bit of a lesser amount of access versus custody being more access. I do also see that there is a question in the chat. Will a de facto parent be able to exclude a biological parent who is not unfit, i.e. recently released from incarceration? So as far as de facto parenthood, again, you need to have the legal or the consent of both legal parents. In the event that one party is not unfit or exceptional circumstances aren't present and you don't have the consent of either one or both legal parents, you don't have a de facto parent.
One of the options here on that question, where a child hasn't been in the one parent's life for some time, is also contested adoption cases. I've done a few of those. You have to prove by clear and convincing evidence that the parent hasn't been in contact for a year, the parent seeking to adopt has had custody for at least 6 months, and that either you have to prove either that there was abuse, that the parent failed to support, or there's no meaningful relationship. And then overwhelmingly, you have to prove it's in the best interest of the child. But incarceration, particularly for a number of years, is a great example where you might want to consider a contested adoption, as opposed to de facto parent or third-party custody, because that completely eliminates the possibility of visitation as well, which some judges then might order.
Yeah, and I would just encourage the participant to read the case of ENVTR. We can provide that site again, but it is 474 MD 346, because that is a very similar circumstance that the court kind of grappled with in this case. And I would read for context also the appellate court's decision and also the Supreme Court's decision overruling that.
Right.
So that just lends some context to the exact situation it sounds like that you're asking about.
Right. Judge Fader, who wrote the first book on family law in Maryland, used to make the comment, and this is back when we had the death penalty, and there were a lot of those cases in Baltimore County, that he would actually rather decide a death penalty case than decide a contested adoption case, because they're extraordinarily difficult for the judges.
Yeah, I mean, custody just in general is often difficult for many judges, and you will see them grappling with these types of cases probably more than is comfortable, I would say. But yeah, these are very difficult cases. All right, I'm seeing another question. Again, this site for ENVTR is 474 MD 346. That's a 2021 case.
And sure, we can put together, for the earlier question, we
Yeah.
can put together a list of cases and sites. That's no big deal.
Absolutely.
Okay, good. All right. Any other
right.
questions? Are you? Sorry, I was assuming that's the end of the outline, Shannon, but maybe not.
Yeah, I don't have anything further on third-party custody unless there are any further questions.
Okay. So I'm going to move on then and talk about sort of marital property basics. And, you know, even in MVLS cases, you will often find a case where there are marital property issues if you're doing a divorce, despite the fact that your client may income qualify to be represented by MVLS, or Women's Law Center does a lot of low bono, or one of the legal aid also has family law representation. The other side may, in fact, have some property. The most critical component of any marital property case is discovery. The first place to go for discovery is going to be the standard form interrogatories that you will find in the back of Title II in the Maryland rules, and they are excellent. I've copied them, both the general ones and the family law ones, domestic. They're usually the first 10 to 13, 15 questions that I ask in all of my discovery. And I've actually put together, which I stole from another lawyer, about 80 to 90 requests for production. That may become problematic because I think there is a rule pending where, like, the federal courts are thinking about restricting the number of document requests you can make. That's actually difficult in family law cases because there are a lot of different types of documents you have to ask for. You absolutely always want to get bank statements going back 3 years. It gives you an incredibly good clue as to sources of income, because pre-separation, people generally are just sticking it all in the bank account, aren't necessarily trying to hide anything. However, these days, in addition to bank statements, Venmo, PayPal, all of the cash apps keep excellent records. It's incredibly easy for someone to download. In fact, it's easier to download Venmo statements and PayPal statements than it is to download bank statements, because the bank statements are monthly. The other ones are just one key. Someone can download it into a PDF. So very easy for you to obtain. And this is one of those areas where the rule is always trust but verify. I am very particular. I do not trust people's financial statement when it comes to income. I subpoena it myself. I make sure I take a look at the bank statements. And by the way, your best resource is your client. Once you have those bank statements, make sure you get them to the client and have them go through it. In the last case I was looking at, the client picked up on literally a $50,000 deposit that I had missed. And it was way, way early, even slightly before the separation. And it turned out that the husband had already figured out there was going to be a separation, had liquidated one of his 401k plans, and had spent the money. And there's a principle called extant property. If you spend that money improperly, gambling, an expensive vacation, jewelry for a girlfriend, taking the girlfriend anywhere, dinners out, that's extant property, and you can get a court to order it put back into the table of marital property. And I'll be clear, in the last case I did, I actually took advantage of the fact that the other lawyer didn't know about the $50,000 because his client obviously didn't tell him, and he really wasn't prepared to prove what his client had done with the money. The funny thing was, I knew the guy had spent it all to pay down his credit cards, which is legitimate use. But he was in some trouble. And while we sort of gave up that issue, it forced the settlement on all the other issues where the person was being unreasonable. So it's nothing like having your client go through all of these documents. The other thing that's critically important is I do a very detailed interview with the client, going through everything: cars, bank accounts, any furniture that might have some value, coins, stamps. Firearms actually have quite a bit of value. And I always ask about firearms, and you can look up their value online, just like you can with cars. Cars are important. So, it's important to find all that out. Obviously, the titling is equally important. The main thing is, if your case goes to trial, you just don't want to be surprised by any of the information about marital property. So, critical things to remember. First of all, when you do the joint statement of marital property, I might have forgotten to include that. Hang on a second. So I'm actually going to send that right now. Nancy, take me 2 seconds. So anyway, I'm going to have Nancy bring this up. This form again is from Sassy Calc. I think I disclosed the first time that the person who owns Sassy Calc is actually of counsel to our firm. We don't have any financial interest in it, but he certainly does. And he's given me permission to give you guys these forms. So I don't know if you have that.
I don't have it yet, Jack.
You should have it momentarily. In any event, the starting point is, what's called the Dozer three-step analysis. Dozer was sort of the first case that talked about what the three-step analysis is that the court must go through. So the first thing they have to do is they have to determine the ownership of all property in terms of title. So if property is titled in the name of one party or the other, with the exception of retirement plans, the court cannot transfer title. Retirement plans, there's a federal law and a state law that explicitly allows the transfer of title. I take that back. And then the other place where they can transfer title is the marital home. If there's any other property, so for example, I just finished a case where my client owned quite a number of rentals. 2 of them were titled in the names of both my husband and wife, and 10 rentals were titled just in the name of the husband. And so you have to make sure you have all of that information, whether you're talking about a car, firearms. Okay. Not sure why, Nancy, because you certainly should have it by now.
It hasn't come through.
That's strange. Okay. There's not much I can do about that. But you got my other email, right? The one with the standards for family law for marital property and divorce.
I have monetary award and amount of award duration. Which
Yeah.
one would you like?
Bring up the monetary award.
Okay.
So, anyway, you have to determine the title and you have to get things valued. Now, there's a critical component in terms of valuation. The owner of a property can always testify about its value. So if you have a marital home, there we go. Just hold it, stay there, just hold that for a second. So
Okay.
if you have a marital home that is jointly titled, tenancy by the entireties, both parties can testify as to its value. In addition, you can use the valuation done by the state on the State Department of Assessment and Taxation website, because that is a public record of an appraisal done by appraisers for the state and is recognized. Now, these valuations are often low. And, you know, you can always get a valuation for $500 from any number of real estate appraisers who do values in divorce cases. If you're the person who has title to non-marital residential real estate, then you probably want to stick with SDAT because it's lower. If you're the person seeking a value that's higher, you're probably going to have to pay for some appraisals. Same thing with cars. The courts will accept an NADA valuation. What the courts will not accept, and I've found case law on this, although very little in Maryland, is you cannot use the websites, and I'm blanking on the name, where you sort of go online and ask, what's my property value? And, you know, they give you an estimate.
Talking about real property, Jack, or
Yeah, I'm talking about real property. So Zillow, for example.
Zillow.
So there are a number
Trulia,
of cases, and the problem with using Zillow is that it uses an algorithm. The algorithm isn't available, and you're trying to use software to basically come up with a value of property that's based on computer analysis. Kind of like using ChatGPT. You just can't do it. However, if I am the owner of the property and I want to come in and testify that the property is worth 150,000, not 120,000, that is on the STAT valuation, I can testify that I looked at a variety of sources. I can testify I conferred with real estate agents. I can testify that I looked at online sources. You can't testify about what they told you, but you can testify about who you conferred with and what information you used to come up with the higher valuation. You can testify that you looked at the price of sales on neighboring properties. So you can say all those things, but you can't introduce it without an appraiser. So that's a critical component. You haven't gotten the other thing yet, Nancy?
I did. I just received it.
Oh, yeah. Let's put
Today.
that up first. Okay.
Okay, let's do that.
There we go. Okay, so if you've done any family law case, you've seen this form. sort of scroll down so that joint statement is at the top. So, the first category here is the stuff that everyone agrees is marital property. Courts do not like it when you start including the knives and forks. On the other hand, if there is furniture that really has a value, you can certainly start listing that. There is case law that suggests, although it is not perfect, that property such as furniture that is bought during a marriage is titled tenancy by the entireties. And the court has the authority to divide up family use property, just transferring it to one or the other. Before that family use property statute got passed, a lot of judges would say, I'm not deciding this property. You really want me to decide knives and forks? I'm just going to send it to one of the local cheapo auction houses, and they're going to sell it all. So you two should come up with a solution. Judges hate dealing with furniture. It's just not something they want to get into. But you can end up with a lot of disputes here. Now, if you go down to section 2, let's bring that to the top. And by the way, I use this form early on in a case to make a list of everything. It tells me two things. One, it tells me where I may need to conduct discovery because I will list stuff. And then if there's something I have a question about, I'll go to the client and either there'll be discovery or I have to get evaluation. I'm not sure why it's necessary to list anything in item 2 if parties agree that something wasn't marital property. However, it can become relevant in alimony. So while courts cannot divide up marital property, people's financial situation, including non-marital property, can be highly relevant in an alimony discussion. So that is really the only reason that you would use this part of the form. Someone inherited $1 million. It's non-marital, but it's certainly relevant to whether or not they might be ordered to pay to pay alimony. All right, let's go on to section 3. Okay. So recently, I've had a lot of disputes here where property or a house, for example, the marital home, was owned before the marriage and remained titled only in the name of one party. And so, and this applies to other property as well. And the question is, what part is marital and one part is non-marital? So there is a really well-known case, and we'll give you the site for this when we circulate the cases, called Grant v. Zich, Z-I-C-H. And this case gives the formula for how you decide that. It's a pretty complicated formula. I have a case where I just won most of the case, but lost part of it dealing with this question. We think the court got it wrong because what you do in Grant v. Zich is eventually you get a percentage of how much is marital and how much is non-marital. And in that case, then the court applied it to the gross value of the property before taking into account the mortgage, which I thought was a really serious error. I think you have to apply it to the net value of the property. And so we're actually going to be petitioning cert on that this week to take it up on appeal. Because these were fairly wealthy people. The marital home was worth a lot of money. No question, there was a big non-marital component, and the non-marital portion was 70%. So if you multiply that against the gross value and then you deduct the mortgage, my client ends up getting virtually nothing. If it's the net value, she gets quite a bit more money. And I really don't understand how the appellate court came up with their decision. Although they got some other stuff dead on accurate. So maybe they were, I don't know, just how the case turned out. So let me just see. Anyway, as I discussed earlier 3 weeks ago, I talked about making liberal use of subpoenas for income information to the other side's employer. But the same applies equally to banks, brokerage houses, Zillow, sorry, not Zillow, but Venmo, PayPal. you can easily issue subpoenas to all these people. To a bank, be careful. They are statutorily authorized to collect copying costs and research costs. And they routinely do that. And if you ask for too much information, you can really end up having your client owe a big check. And then the problem is also they like to bill the lawyer, even though I don't think they can do that. But you just want to avoid that kind of dispute. Typically, however, getting 3 years worth of bank statements costs $200 or less. So if the other side's sort of claiming something's unavailable, or their bank only goes back 12 months or 18 months, and you really think you need the information, issue a subpoena. It is no big deal. The one weird thing about issuing a subpoena to banks is that banks are not required by statute to have resident agents. And it's an oddity in the law going back a really long time. But if you have Bank of America, just walk down to your nearest bank or have your process server go into your nearest branch and serve the branch manager, and you're done because they're an authorized agent of the bank. Sometimes I just look up who the president of the bank is in Nebraska or wherever it is, and I put their name down and I send it by certified mail. That actually usually works. Some banks have a subpoena department and you can issue the subpoena to them, but it can take some real research to track down who those people are. And, I don't want to spend hours on this. But it's really easy to do. It does not take that much time to write up subpoenas and the notice of deposition you have to do with it. And you want to do it reasonably early on in the case, depending on the jurisdiction, because discovery deadlines, of course, creep up on you pretty fast. So anyway, so as you can see here, basically you have to have the title to property, you have to have the value, and you have to have whether or not it's marital. And that is the analysis that the court does. And there's any number of cases, starting with Dozer v. Dozer. Let me write that down because I'll make sure we get you a copy of that case, that basically tell the judges how to go through this analysis. Step 1 is determine who owns the property. Step 2 is determine the value of the property. Step 3 is apply the factors, which we're going to get into in a minute, and then divide up the property. Okay. Oh, that's a great question. All right, I'm going to come back to that question, Geraldine, because that is a great question. Okay. I've had that come up more than a few times. So now if you can now bring up the factors, that'd be great, Nancy. There we go. Okay. So before I get into these factors, I will make the comment that Maryland, as you know, is what's called an equitable distribution state. All right. Almost all the states except Louisiana that are east of the Mississippi are in fact equitable distribution states. When you get west of the Mississippi, you start getting into, oh my God, Shannon, I'm having a senior moment. California, community property states.
Community property.
Yeah, thank you. So the key thing there, however, is the word equitable distribution, not equal distribution. On the other hand, it is a rare day that courts don't make equal distribution of marital property. There's just no reason for them not to. They're not inclined to do it. You have to give them a really, really good reason to not make an equal distribution. And I can give you 3 examples I've had in my career, and then one really bad one that happened to me that I appealed twice, and on the second time, my client finally just threw in the towel. So in order to get unequal distribution, there has to be some factor that really sways the court to deviate. So the first one is egregious marital misconduct. I will tell you that adultery, while it's still a factor when we go through this, probably is not sufficient for egregious marital misconduct. Egregious marital misconduct, in my mind, in terms of affecting marital property, is something like child abuse, particularly where, there's a lot of expense in terms of dealing with the aftermath of the child abuse or a lot of emotional distress. The most significant case I had along these lines was the client went to jail, then he violated the terms of his probation, and he went back to jail to serve his full sentence. He violated his probation by trying to contact the child after he got out of jail the first time, who was then 18, and the judge was not amused and just gave him the full sentence. In that case, the judge basically made about an 80,000, 20,000, or an 80%, 20% marital property award. And we got the rest of the 20% of the marital property by suing the abuser in tort for battery. And basically he threw in the towel and just gave up the rest of the marital property, which was basically the marital home, which the abused child wanted to make sure her mother got. The second example, this is more common, is if you have a real age disparity between the parties and one of the parties is nearing retirement. And so courts may do an unequal division of the retirement assets. So if you have someone who's, say, 60 years old, they're going to be retiring in 5 years, they're married to a 40-year-old, a lot of courts will consider doing an unequal division of the retirement assets because the 40-year-old presumably is going to have another 25 years to earn her own retirement assets. The 60-year-old is not. So that is the second example that I can give you of an unequal distribution. The third one I had was where a judge just really didn't like my client. And I never understood why not, because it was really, in my mind, the other party who had engaged in bad behavior and gave my client a zero marital property award. I took it on appeal because she made a bad ruling on the pension. She got reversed, reaffirmed her ruling, was unbelievably discourteous to me in the courtroom. I took it up, reversed her a second time, and my client was exhausted by then and just gave it up. And I actually didn't really charge him all those fees. I was so appalled by what the court had done. But that was a really, really unusual situation. And I'd heard other commentary about that particular judge. Fortunately, in this state, I could list on one hand a number of judges who I think can be off in court. I think we're very lucky in this state with the judges we have deciding family law cases. Anyway, let's just, if you can just go down to item 2. Okay, so I'll stop there. So this is a critical statute. The court can transfer title or ownership in a pension or any kind of retirement plan. It is important here, although probably we'll never run into this, but I'll just mention it. Most retirement plans are either government retirement plans, federal or state, or what's called ERISA retirement plans. In other words, they are controlled by federal regulation. ERISA stands for the Employee Retirement Income Security Act of 1974. You do not need to read that law. It is long, it is complicated, it is really hard to understand, but you can find summaries that point you in the right direction in terms of retirement plans, and you're rarely going to have to make a deep dive into that statute, thank God. I don't know who wrote it, but it was someone who really wanted to torture lawyers. They can transfer title in family use property, and there is a definition given of that in the definition section. All right. So typically that is property that you use to live in. And then thirdly, the marital home. They can either transfer the ownership upon such terms as the court may deem fit. What's interesting about this is if they do this, they do not need to do an equal division. So for example, the property could have $100,000 in equity, but they could order that husband gets the home. He can, as long as he refinances, which is a requirement of 231 that you're looking at, they can say that all he has to do is pay the wife $1, even if there's $100,000 in equity, because that's what the court considers equitable. Okay. In a case involving serious domestic violence and where a wife had been paying the mortgage for 5 years, the court did just that. My client refinanced and then she owned the home. The husband didn't get anything. Or they can authorize one party to buy out the other, or they can just sell it at auction. So that's something to consider, because very often one party wants to buy out the house from the other, and you need to figure out how to do it. One of the big arguments that I've seen when this is being done is one party will argue that if they're buying the house, they ought to get a credit for the closing costs that they're saving the other party. If I'm the party being bought out, I never, ever, ever, ever agree to that, no matter what. I just hold the line on that. And I tell people, if you want that, find a judge who's going to order it, because I don't think they will, because it's not a real expense. They want to buy out the house, they buy out the house. All right, let's go down now to 3, next section, or B, actually, right there. Required stuff, go back up to 1 here. So required considerations. So most of these are almost always equal. So if you look at item 1, the contributions to the marriage, well, it really doesn't matter if one party worked and one didn't. I always get, usually husbands, but occasionally wives, who say, well, I made all the money. I bought all this property. Why should they get it? Yeah, they raised the kid for 7 or 8 years, but after the kids were in elementary school, I told her she should go get a job. She never did it. And now, 10 years after that, you're penalizing me because she didn't work. I can't tell you the number of times I've heard that argument from my own clients and from men on the other side. It is total, absolute, misogynistic, since it's usually men, nonsense. Okay? No judge is going to go for it. And I can assure you, when judges go to baby judge school and then they actually go to baby judge family school these days, thank goodness, that's what they're told, which is you got to ignore that argument. Item 2 can sometimes be more important, although usually not in marital property, more in alimony cases. But you'll notice the value of all property interests. So, it may be the husband owns $5 million or $5,000 or $10,000 of his own money that's non-marital and the court can't touch. That is something the court factors in absolutely in making a marital property award, and that can sometimes matter. The economic circumstances of each party, I've never really seen a judge factor this in, because even if one party's making a lot of money and the other party isn't, the place where you would normally equalize that is with alimony, not with marital property. Circumstances that continue to the estrangement of the parties. So as we talked about earlier, when we talked about grounds for divorce, adultery, alcoholism, drug addiction, gambling losses, child abuse, domestic violence. These are all circumstances that can contribute to the estrangement of the parties. Typically speaking, courts don't factor that in my experience in marital property. Duration of the marriage. This really only matters on the short end. When you have parties that have been only married a year or two, I've very often seen judges go, no, this is a walk away. I'm not making a marital property award. I recently had that happen in a case. In that case, the wife was pretty, I don't like using the word crazy, but let's just say not rational in the arguments she made to the court, and the judge just rejected it. They've been only together for 1 year. Frankly, I think she had more property than he did, not maritally, but the court gave each party. I just said it's a walk away. The judge agreed with me. Duration of the marriage, that's what I just talked about. Age of each party. That can matter if there's a big age disparity. Physical and mental condition of each party. Again, I don't think that matters for marital property. I think that's more of an alimony factor. If you can go down now to 8 and what's left at the bottom. Let's see if you could scroll that down to 8 at the top. Okay. How, bring it down, just go, but no, go back down. There you go to 8. It's there, stop. Okay, perfect. Thank you so much. How property was acquired. I don't think it matters. I have never seen a judge factor that. 9, I one time had a judge after a 20-year marriage give the husband back the $20,000 his parents had loaned him 20 years earlier, 3 houses before. And I was a little shocked at what the judge did. I was really, really offended by that. First of all, there was no reason to think it wasn't a gift to both parties. Secondly, they've been married for 20 years, and it was ridiculous to think that they were in any way entitled to the money back. The judge did it, and anyway, we didn't bother appealing because it was so little. Any award of alimony or family use property, again, I don't think that that's something a court should factor in, but it's something the court has to go through. Any other factors? This is really important. So first, let me talk about 1 through 10. When you're in court with a good family law judge, and sometimes when you're in court with people who know they're not a great family law judge, and there are a lot of judges who acknowledge they don't like family law. They don't like doing the family law rotation when they're in one of the 5 large counties. They avoid it like the plague. When they are in family law, they try and not get the long trials. They try and get the assignment people to give them the other family law cases. I'm thinking of one judge in particular who I love, but he does not like family law. And the judges, will then, as they're making their ruling, after they make all their findings of fact, will literally go through these factors one by one by one. The case law says, if you take an appeal, if they don't, the appellate court will assume that they still considered all the factors. Okay, so you cannot get a case reversed just because they don't go through all the factors. But it puts the judge in more danger of being reversed if he doesn't. And so most judges will go through. When a judge doesn't go through the factors, and they've said something earlier by mistake, where they implied that they weren't considering a factor, then you start having legal grounds for a reversal. Let's talk about 11. Any other factor. So this is where debt comes in. So during a separation, a case my wife had many, many, many years ago, she was actually the child's attorney, 3 children's attorney. And the husband worked in the family business. He did not have an ownership interest yet. So there was not a lot of marital property because it was really owned by his father. He made a good income. The wife had a professional degree, but during the separation, categorically refused to look for work. Just fine. That's appropriate for a certain period of time during the separation if you have a spouse who's not working. But at some point before the final trial, they have to start being able to tell the court what they're doing about becoming gainfully employed, assuming they're not disabled. And I'll talk about that more with the alimony section. And during that period of time, she had, despite getting both temporary alimony and substantial child support, somewhere around $4,000 a month, and living in the marital home free of charge, ran up $100,000 in credit card debt. And the court factored that in and basically ended up having it be a factor against the wife and didn't award her alimony. I remember that got appealed and the judge was affirmed. He just felt what the wife had done was outrageous, that any alimony she had gotten would have been for a period of years as rehabilitative. And as far as he was concerned, the $100,000 was an advance on that. He was not going to award her alimony. It was a pretty harsh blow. The other factor, however, is that the mom had also really done a job on the kids and seriously alienated the kids from their father. Her conduct was pretty egregious. There was really nothing wrong with this guy that my wife could figure out. I was sort of listening on the sidelines. It was actually before we started practicing together, way early when she and I got married, so it's 30 years ago. But I always remember that case. So that factor in terms of debt can become very important. And that's true whether you're dealing with people who are low income or high income. If you have someone who is the economically dependent spouse, but the economically superior spouse has $30,000 in credit card debt. Maybe he's making $50,000 a year. That's definitely a factor a good lawyer can use against you in terms of a marital property award, because he's got to pay off that debt. So that's pretty important. All right, let's just go down to next one, award reduced to judgment. So this is a really crucial component here. So when you have a marital property award, often you have people who don't have cash, but who have assets, particularly if there's a house that's non-marital. And that's titled in the name of one party, and they're not going to transfer title. What they're going to do is enter a marital property award for the house, which is the more common outcome. And the person doesn't have money. The rule of thumb that I go by is that judges will usually go up to 5 years. So they'll say, okay, you owe $60,000. You got to pay $10,000 within 30 days, another 10 a year from now, and another 10 every year thereafter for 10 years. If you don't pay it late, you can have it all reduced to judgment, or they can just order that the late part is reduced to judgment. So the court has broad discretion here. And this is an area, if you have a newer judge, you really want to educate the judge. More experienced judges in family law pay attention to this, know about this. Less experienced judges, especially if they're doing their first rotation in family law, and you're the person who might have to pay money, you want to make sure you educate the judge. Because if you educate the judge early on, before they make the decision, I know in Baltimore County, I wonder who they confer with now. They used to confer first with Judge Cox or Judge Jacobowski in Baltimore County, or in Baltimore City, they would confer with Judge Panos or Judge DiPietro, because they have broad background. Although I was just in front of Judge Pietro, who even after 5 years hadn't dealt with the pension situation I was dealing with, because they see so few marital property cases in the city. But this is a really important provision to keep in mind. Okay. All right. So 10:30. Any questions so far about this? So that's a lot of data. Okay. So probably, Nancy, it's a good time to take a break.
Okay.
Almost 10:30.
I think let's take a 10-minute break
Okay.
and we will resume. What time do you have, Jack? I have 10:20.
Yep, that's what I've got.
Okay, we'll resume at 10:30 and we'll see you back. Same
All right,
time,
great.
same place. Okay.
All right. Yep. See you then. Anytime you're ready, Nancy.
Okay, we're ready to go. What do you need from me, Jack?
I'm gonna answer that question. I forgot about it. And then we'll put up the factors for alimony.
Okay,
And
we're ready.
we'll actually go to the bottom first for alimony
Okay,
of that statute. But
all
whenever you're
right.
ready, I gotta close my door. Oops.
Stay with me. I will
Yeah.
be. All right.
Okay. So before I get on to alimony, I forgot to answer is it Geraldine's question about property titled with a grandparent or a third party. So that is a great question. This does come up, particularly with regard to a marital home. And the answer is I don't think the court has the authority to sell the full interest in the marital home. So all they can do, if it's jointly titled by both spouses with the grandparents, is they can probably transfer the partial interest from one spouse to another. That's one option. I don't think they have the authority to appoint a trustee to sell the home in its entirety. I mean, they could appoint a trustee just to sell the 1/2 interest, but that seems like an exercise in futility. So, you know, it creates a dilemma for the court. In particular, there was a case recently with Judge King, who just passed away, and he really didn't like the appellate decision that reversed him. The grandparents filed to intervene in the divorce because they owned half the house, and Judge King let them do it. And the appellate court said you couldn't. If the grandparents wanted to take legal action with respect to the house, and I think it was either a claim for contribution or for return of some, or for, they also claimed to have a lien, they had to file a separate lawsuit. So I guess you would file a separate lawsuit and then move to consolidate. But it can get messy, to say the least. So I don't know if that answers your question, Geraldine, but that's sort of the best I can do with that one. You know, one of the things that you occasionally see done is sorry, I apologize. That was my phone going off. I have one phone shut off, but not the other. There we go. So, you know, where they claim an equitable lien because they made an unsecured loan. I have a case like that right now, where the uncle loaned money to both parties. There's no mortgage document. There's nothing in the land records. But on the other hand, the uncle has an amortization table and a history of payments that were made by the husband on behalf of the married couple for a decade. Well, that's pretty solid evidence of a lien against the home equitably, even if it's not legally. So that's the best answer I can give you. All right, let's talk about alimony. So, a court can, and I'm not going to bring up the statute, basically award 3 kinds of alimony. And I haven't pulled up the case law on the first 2 kinds, but these are very, very important in MVLS divorce cases or any divorce cases where you're representing the economically dependent party and where the spouse has income, even if they're not a high earner. So if you have, say, someone who is partially disabled or has limited education or limited skills, and you know, they're going to get a job working, you know, as a server. I guess we don't call them waiters and waitresses anymore, as a server, or basically their income earning potential is really on the low side. It doesn't matter if the other party only makes $50,000 a year or even 40. It's still potentially an alimony case. I mean, I think minimum wage these days puts you slightly over 20,000, but Nancy would know better than I do. I haven't looked at the income guidelines in a while. There's the real potential for alimony. If you have a long of a marriage, a potential for indefinite. So let me talk about the three kinds of alimony. First, you have what's called status quo alimony. So during the pendency of a case, you can get alimony to maintain the standard of living status quo during the divorce. To do that, when you go in for your scheduling conference, make sure you ask for a pendency lite hearing. More importantly, you must, early in the case, within 15 days of your answer, if you're the one being sued, or with your complaint of divorce when you're filing, file a long form financial statement. A copy. Have we circulated stuff yet, Nancy? You're mute. You're muted.
Muted.
Still muted. But anyway.
I have not circulated the
Okay.
materials yet. I will do
So,
that at the end.
Yeah, so we're circulating a really excellent, fillable, long-form financial statement that does all the totals. That's the exact duplicate of the statute. You must file that. And I'm going to talk about that form a fair amount, so I may ask you to bring that up, but let's just stick where we are for the moment. Okay, but anyway, so that's the status quo or pendente lite alimony. Then you have rehabilitative alimony. And rehabilitative alimony, is paid so that someone can get back on their feet. Either they haven't been working for a while and need to re-enter the workforce, and usually you can get alimony for anywhere between 2 to 5 years, depending on how long the marriage is and the needs of the person. Or you have a situation where someone has a plan. It's not a long marriage. And I don't think courts necessarily look to the length of the marriage as much for rehabilitative alimony. Although if it's 1 or 2 years, you're not going to get it. But if it's 5 or more, you might. And you come to court with a plan. Your Honor, I'm going to go back to school. I'm going to get my 2-year degree or my 2-year certificate in HVAC repair. Or I've got 2 years of college. I'm going to go back and I'm going to get my bachelor's degree in social work. And then I'm going to get my master's degree in social work. They've figured it out. They've looked at the tuition costs. They've looked at what schools offer the program so that they can, present a plan to the court. So that's rehabilitative alimony. One of the things that other states have that Maryland doesn't is alimony for a period of years just because, okay? Not because there's rehabilitation, but because, they've been married 10 years and the wife makes a lot more than the husband. And so they're going to give alimony to the husband just for a period of time. Some states allow that. The trend, however, particularly in some of the more conservative states, and Florida and Texas in particular come to mind, have come very close to abolishing alimony. And I think it's a horrible trend. I can't think of her name right now, but she was one of the leading feminists of her time. She's still alive. I wish I could remember her name, but, she said one of the biggest regrets from the feminist movement was the idea that alimony should be abolished because it's misogynistic. And she came to realize after a time that that was really legally incorrect, that it was totally appropriate in a marriage to award alimony where appropriate. So, you really want to look at the question of alimony. Here, if I'm showing you right now, are the 2 grounds for getting indefinite alimony. So the first is disability. Typically speaking, the courts in a shorter marriage will look for the disability to have occurred during the marriage. Shannon and my partner, Deborah, had a case or I think you worked on this, Shannon, I could be wrong, where the wife literally, oh no, I know, it was Stepper, my partner, Stanford, hadn't done a trial in a while, but the wife literally had taken a header off a ladder the day after the husband said he wanted a separation and had permanent brain damage. The husband fought it tooth and nail, and we had to bring in the doctor and a psychologist to testify about her injury. And, you know, that's crucial, by the way, for disability. You have to prove it. You can't just come in and say, well, the person's getting SSDI. If you look hard enough, you can probably find a doctor who will testify by video or remotely at no charge. You know, but at the end of the day, you may have to ask the court to award a payment, or worst case scenario, you can just subpoena the doctor without payment. There is no legal requirement that you have to pay a doctor first. You can subpoena the doctor and then ask the court to decide who should pay him. I can't say I've ever done that, but it is something that's permissible. In cases of a longer marriage, if the person was disabled even before the marriage, I still think a court may award alimony, but I think you're looking at least a 20-year marriage. Then you have item 2, which says, even after the party seeking alimony will have made as much progress toward becoming self-supporting as can reasonably be expected, the respective standard of living of the parties will be unconscionably disparate. So the rule of thumb here is usually you have to have at least a 2-to-1 ratio of income between the parties. I've never seen alimony awarded for anything less. And I've rarely seen it awarded for marriages of less than 20 years. I one time saw it awarded for a marriage of 10 years. But I will say that the husband's conduct, when you get into the factors, was kind of egregious, and the judge was ticked off, didn't like it. Okay, so there are rare exceptions to that 20-year rule. And by the way, if you're in Howard County or Montgomery County, the rule of thumb these days for a while now is more like 15 years. So, by the way, 1 out of every 5 cases in Montgomery County are 2 professionals, a professional woman who left her profession to have children, who was a substantial earner before, the husband is a substantial earner with incomes of $500,000 or more. And so that's a different world in terms of alimony. We don't typically see cases like that. Montgomery County, now Howard, they see cases like this day in, day out. They're constantly dealing with alimony cases. And people throw a lot of money at these cases. It's a good place to be a lawyer if you're doing family law. All right, let's go up to the factors then if we could. Yeah, so the factors are almost identical, but they're sort of applied a little differently. Let's go back up for a second to the part.
Back up?
Yeah, back up for a second. Okay, so this just says basically that the alimony can be retroactive to the filing. And then at conclusion, no further alimony will accrue. So if the court orders 5 years of rehabilitative alimony and you don't ask for modification before the 5 years are up, you can't come back. All right, so let's go down to the factors. So number 1 is probably the single most important factor, the ability of the party seeking alimony to be wholly or partly self-supporting. That is absolutely the number 1 factor. Number 2, also critically important, the time necessary for the party seeking alimony to gain sufficient education or training to find suitable employment. 3, the standard of living, also very important. I had a very, very oddball case. I actually just ran into the lawyer who was on the other side for a while recently, where the husband made all kinds of money, but he never spent any of it. And the wife didn't know he was making all kinds of money. And the husband, who kind of was raised poor and was somewhat middle class, you know, kept telling the wife, oh, honey, we've got to cut back on our expenses. You know, this year, the household budget is going to be, you know, $4,000 a month. Well, the guy was making $500,000 a year, right? He never spent it. And the wife didn't even know. And so when you talk about the standard of living established during the marriage, and thank God that's only one factor, you know, oh, the answer, it's EL, I think is how you say your name. The answer is it's in the Maryland rules. It's under Rule 9203, which says when you have to file a financial statement if it's the answer that you're filing. So you file the answer, you have 15 more days to file the financial statement. That's if the other side seeks alimony or if you're seeking alimony. Although if you file a count, because you can ask for the alimony in your answer these days. We talked about that in the pleading earlier 3 weeks ago. All right, but good question. All right. Duration of the marriage, again, 20 years for indefinite, certainly 5 for rehabilitative. No time period really for status quo, but you won't see that too often. Contributions, non-monetary and monetary, you're almost never going to see a court consider that factor because the non-monetary contributions are always as important as the monetary, especially when one person is staying at home or spending more time raising the kids. The circumstances that contributed to the estrangement of the parties. Unlike marital property, I have often seen courts really consider this in alimony cases. Years ago, about 10 years ago, I was the moderator for a panel of 5 judges, and someone asked about this question, and the judge who answered it said, well, I'm not going to award alimony because someone engaged in marital misconduct. But if alimony is warranted, it's certainly a factor where if there's marital misconduct, I may increase the amount I award. I had a case where husband married his sweetheart when they were about 20 years old. When he was 30 and they had a couple of kids, he divorced his sweetheart and took up with and married a 20-year-old. So from no age gap to a 10-year age gap. Then when he's 40, he decides to divorce the 30-year-old and, oh, what does he do? Takes up with a 20-year-old. The judge was so not amused by that. He found it really appalling. I gotta say it was kind of off. And really hammered the guy pretty hard. He hammered the guy too hard, actually. Part of the alimony award was reversed, but the basic part of the alimony award was affirmed by the appellate court. I actually only handled that case on appeal. Age of each party, that starts really becoming important if the economically dependent spouse is 50 or over, because especially for women, but men also, when you hit the age of 50, your ability to start a new profession or to re-enter the workforce is statistically much more difficult than when you're younger. There is a lot of discrimination against older employees. There's a lot of discrimination against older people seeking employment, especially in the professional world. And I think judges, who are almost all over 50, are pretty aware of that. The age of each party probably really doesn't matter. Physical and mental condition is critically important in alimony cases. The ability of party from whom alimony is sought to meet the party's needs. So this becomes a very difficult factor for the judges, especially in lower income cases. Because the fact of the matter is in divorces for lower income people, middle income people, anyone except for the very well off, there's simply not enough money with the combined incomes to go around to support 2 households when it was only supporting 1 before. So the fact of the matter is the person receiving alimony probably isn't going to get enough alimony to meet what the status quo was during the marriage. And the person against whom alimony is awarded probably can barely afford to pay the alimony that's awarded, especially if there's also child support, because there's just not enough money to go around. And that makes these decisions for the judges pretty difficult, although most judges have an easier time dealing with financial issues than custody issues, because at the end of the day, it's money, not children. Any agreement between the parties. Sometimes you have this, or someone can find a witness who, heard the wife promise the husband, or heard the husband promise the wife, oh, don't worry, if, we ever get divorced, if we ever, break up, I promise I'm going to take care of you. That's not unimportant if it was really meant that way. Financial needs. So we're going to get into the financial statement in a minute. So all income and assets are included, including non-marital income and non-marital assets. So if I've got $2 million in the bank, and I know this doesn't apply here, it's by way of example, obviously, I'm making at least $100,000 off that, 5%, non-marital, but definitely something a court can factor in for alimony. Courts have to coordinate. This is a really important 10 Roman, small Roman 2. The judges must coordinate the alimony award and the marital property award. And it is fairly important when they render their decision that they say so. Okay. Now, again, they're not going to get reversed if they don't say so. The law is clear on that, but they leave themselves open to reversal for other reasons if they don't make it clear they've done that. Nature and amount of financial obligations of each party. I'm not sure why that's any different from the ability of the person to pay or the need, but it's sort of there a second time. And retirement benefits can become particularly important in alimony awards. When you're negotiating alimony, whether you've got well-off people or not well-off people, the person seeking alimony is going to probably want it till like age 70, because that's sort of the maximum age where you got to start collecting Social Security. The person paying alimony goes, no, 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 no. She knows I was always going to retire when I was 65. Always. They know that. It's not reasonable. They can't ask me for, to pay longer than that. Often there's some compromise. All right. All right. Let's see. Let me read this. Yeah, so 12 is just, you can't award alimony and put the person into poverty, basically making them eligible for medical assistance. I've never really seen a case like that, although I guess in low income cases you could. I don't know how you would even apply that factor as well. All right, let's bring up the form if we could then. So while Nancy's bringing up that form, you should know that the introduction to the alimony chapter in the book that Shannon and I are co-authors on, or in the other book that is published by Tom Reese and Judge Cindy Callahan, the alimony chapter starts off the same way for both, which is that there is no aspect of family law or probably any other area of law that is more judge dependent than alimony. Every judge is different. Because I practice around the state, I try and get myself very, very educated on the judges and what their predilections are. So for example, Tim Martin was very, very conservative before he retired about alimony and considered it something really, really extraordinary. Other judges think that it's something more liberally given. So, you just see a lot of variations. Okay. All right. Stop there. Go back down. So let's just go back. You can skip go to the top where it says primary residence. Sorry, I'm not being clear, Nancy. I apologize. Have where it says primary residence at the top of the screen. Just go down a bit.
Tell
There you
me
go.
when.
Right there. Hey,
Got
section 8. Yeah, right there. Okay. So I am ruthless about the financial statement. Okay. I will sometimes, usually, try and have my client fill it out themselves so that I don't have to. And then I don't have to charge them for it because it can be quite time consuming. However, as with much of the population, there are a lot of people who are just not good with math, that can't balance their checkbooks, can barely go through their checkbooks to like get an average of their BG&E bill, for example. And so there are just some clients that you're just going to have to work with on this. It's really important to have this financial statement be as accurate as you can make it at the beginning of the case when you file it. And it's not always so simple. So some things are easy. Rent. Okay, well, you know what the rent is every month. That's not going to change. Gas and electric. Well, it's easy enough to get an average of 12 months. Same thing with your water bill. Same thing with trash removal. Same thing with your cell phone. So there are categories of things where either you can get an average or your monthly amount is the same every month, where it's really easy to put in a number and you're not even going to have to remember how you came up with a number. Let's just go to the next page for a second, Nancy. I think there's some good examples of things that are not so easy. All right, stop there, for example. Like you see painting and wallpapering or domestic assistance, housekeeper, pool. You know, those are some expenses where you really may have to take a few minutes and try and figure it out. Replacement furnishings, appliances, painting, wallpapering, and then there was one, it's, don't need to go back, you know, that are little better than a wild ass guess. And so you do your best. Then there are some expenses that you're just not going to know until you get divorced. First among these is always health insurance if you are on the other party's health insurance. You just don't know how much that's going to be. So all you can do is guess. And if you have someone who works for an employer, either the state, the feds, or a private employer who subsidizes the health insurance in whole or in part, it's really hard to figure out what's going to be. Sometimes you can ask and find out how much COBRA would cost, and you can put that down. And sometimes people are not so cooperative. The critical thing here is, and they don't have the footnote column here, so I don't think they use the same form that I use. But the form I use is a place for footnotes. It is really important for the things that are not obvious monthly expenses to write a footnote down of how you came up the number. And the reason for that is this form is definitely subject to cross-examination, okay? And a year after you do this form, when you finally get to trial, neither you nor your client are going to remember how you came up with a lot of these numbers. And so you need to keep footnotes on how you came up with the numbers so that when you ask for the question, you know, well, how did you come up with the replacement furnishings, blah, blah, blah. Well, that one is probably okay to say, I guessed, right? Because some you really guessed. But on the health insurance number, you know, it's useful to be able to say, oh, I went and found out how much COBRA was on my wife's health insurance. And the judge will then kind of nod. But if you're sitting there going, oh, I don't know, I don't remember, you know, that is not great testimony in front of the judge because they're trying to figure out how to cut back on how much you're requesting for alimony for two reasons. One, they know you've asked for more than you really are entitled to because everyone does that. And two, the other party really is going to have a hard time paying it. And that's true in almost all alimony cases. So they're going to look where they can cut back. All right, let's just sort of keep going down for a bit. Nothing I didn't. Oh, go back up to primary residence, just to A for a second. I just want to comment on one thing. You'll notice here that it's 1/3 of every expense for the house for the primary residence is for the spouse seeking a divorce and 2/3 for the children. Normally, if it's a spouse plus maybe 2 children, I'll divide this in half. If there's 3, 4, 5 children, 6, I'll do 1/3, 2/3. There's no hard and fast rule on this, but that's what this is trying to find out. How much of this expense is for you and how much is for the children? Not that you'll have over guidelines with combined income of more than 240, but if people can't agree to extrapolate the guidelines child support, that's what you're supposed to use under the original child support cases. And that is still the law today. Everyone forgets. Everyone uses extrapolated guidelines, but that's usually by consent. If both sides don't consent, the court has to go through all these expenses for the children and figure out what their expenses really are. All right, let's just go down to section C. This, by the way, yeah, there we go. This, by the way, is a form that was prepared by an opposing counsel in a case. I thought they did a really brilliant job. And so I've always used this as the example of how to do a financial statement. It was just phenomenal. And by the way, you can see this is from some time ago. If you have 2 kids, and you, $1,000 a month, maybe, and if you have teenagers, for sure more, especially if you're getting all your household supplies, over-the-counter medications, and everything else like that at the grocery store, it's going to be more than $1,000 a month. The grocery prices have increased shockingly over the last 3 years. It's really quite something, as I'm sure everyone on this call knows. All right, let's go down to medical dental. Again, really important. So health and therapist, counselor. So, most good therapists don't take health insurance. And it's hard to find good counselors who do take health insurance. Curiously, in Baltimore City and Baltimore County, there are more good therapists on the east side of town who take health insurance than there are on the west side of town, which is somewhat more affluent. On the west side of town, it is very hard to find therapists nearby who take any kind of health insurance. The 2 examples I know of who do take health insurance are Franklin Psychiatric Associates near the hospital, and also Jewish Family Services. And by law, they're required to take any patient. They're actually pretty good at what they do, although I think most people are inclined not to go there if they're not of that ethnicity, but they are there. Extraordinary medical expenses. You definitely want to pay a little attention to getting this right. Dental orthodontia, glasses, and I don't know why it's only $8 for glasses. That's incredibly cheap. Maybe that's just for the annual appointment or something, because, eyeglasses are at least $200, $250 for 1 pair. So, all right. Then you've got school expenses, tutoring, extracurricular activities, gym clothes, nursery, and this is also where tuition would be if you've got a kid in school. And I've seen a lot of low-income people have kids sometimes in private school in the city where they can, if they can get a scholarship. Keep going down, vacations. This is one of those ones where you really don't know how much it is. I mean, that's almost $11,000 a year. You're probably not going to see that, but your family may take a week at the beach every year. You want to make sure you include that. Judges will usually leave that expense in if it's reasonable. Dining out is a classic one where they'll cut back. Sports for the kids, they will usually leave in, although $6,000 a year. You must play lacrosse. That equipment is crazy expensive. Transportation expense, that's usually kind of easy to figure out. You can usually guess about gas. When you see gifts here, judges will take a really hard look at that to figure out where to cut it back. They often will not allow any gifts to charities. You'll have a lot of clients, even low income, who tithe, and judges will usually not consider tithing either in either side's request in terms of tithing. Let's keep going down here. Clothing, I mean, these are actually pretty reasonable numbers. One of the reasons I like this so much. And I like what the guy did with attorney's fees, although you probably won't see cases like this with your low-income clients. But he basically took it and divided it by, I'd say about 8, okay? I mean, a judge may divide it by more, but that's a really good way to do this. I mean, you've got to come up with something where the person owes you back attorney's fees. And unfortunately, we see that all the time. Let's keep going down. All right, alimony from a previous order. So I guess the guy was married before. Haircuts, so on. Miscellaneous pocket money. Total deductions for income, 12,000. So the guy was making about $144,000 a year. And stop here. You'll see where he didn't bother individualizing federal, state, Medicare, FICA. I don't think most judges are going to care because the number's pretty reasonable. Other gross income, we don't know what that is. Keep going down. All right. He didn't fill out the asset part. However, you should. So, but some judges don't pick up on that. You know, if I'd gotten this financial statement without the assets, I would have filed a motion for more definite statement and asked the court to order them to fill it out. So, okay. Keep going down. I think that's about it. But you'll see where classic, go stop here. Classic, you'll see where the income is way overwhelmed by the expenses. Okay. You're almost always going to see this both for the person paying alimony and not paying alimony. They're going to claim I'm spending more than I make. And judges are like, well, unless you can show me credit cards where you're really doing that, you're not. You're only spending $8,000 a month. And judges don't like this very much. You know, people think that it's like evidence of something. Now, if it's really true, if you're the economically dependent party, that's one thing. But if you're the economically superior party, you know, the judge knows immediately that that's nonsense. Just no way that that's true. And it's kind of nonsense in this case, but I still like the financial statement. He really did a good job on the itemizing the expenses. Ah, I see. Did a separate spreadsheet. I forgot. Okay. Okay, and that's the other option is you can do that. They really want you to use the court form, though, I think, for the expense itemization, just because they're used to seeing it. One of the things, by the way, that I do, especially when I have someone who is not skilled on the finances, is if I know that there's an attorney on the other side when I'm filing my answer, and so I'll ask them, do you mind if I file my answer? And I'll file the financial statement 45 days later. The other side will usually agree because they want to get the answer filed so they can get going on the case. So, you know, that's just a matter of professional courtesy. But I've done that quite a few times. If it's a lawyer I don't like and they didn't file it and they didn't ask me, I'll usually file someone. But I don't do that very often because, quite frankly, I don't like filing things that don't make a difference just because I'm busy, as we all are. All right. I want to say, keep going down there a little bit. I think that's it. Oh, liabilities. Yeah, so this is being circulated. So like I said, I really like the job they did. And whether it's high income or low income, you know, this is really good to take a look at. Okay. Oh, and there he put in the detail on all of the deductions. So, and by the way, the 401k loan, that's important because 401k loans are actually part of the asset because the person is paying money back to themselves. That's just a little detail to remember. And the retirement, you want to see if it's required or not, because if it's not required, most judges will add that back in. Judges aren't going to be interested in 401k contributions greater than what you get for the 3% match. So if you've got someone socking away more than 3%, most judges will add that in on the income side. HSAs, they will usually allow because we have all these really crappy high deductible plans. Okay. I'm going to give one more answer to your question about when you file your financial statement. If you're the one seeking alimony and you've been served with the divorce papers and you normally, I wouldn't rely on filing an answer. I would file a counter complaint. When you file the counter complaint, you must file a financial statement, but there's no timing requirement on filing the counter complaint, although sooner is better than later. Okay, good. All right. And that's about it, unless people have questions. Okay. Shannon, back over to you on
Ready
child
to
support.
move to child support?
Yep. And I think we'll probably be done. Well, we'll see when we're done. We may be done before noon, but we'll see.
Okay, so shifting gears just slightly to child support. Why do we have it? Well, the federal government required each state to establish guidelines for calculating child support awards. And back in 1990, Maryland's General Assembly enacted legislation making the use of child support guidelines in this state mandatory, creating a rebuttable presumption that the guidelines amount was correct. So the guidelines increase consistency, predictability, perceived fairness in determining child support awards. And while this is, I'm sure, more information than you need, in coming up with the guidelines, the states must consider the economic data on the costs of raising children and the labor market. They consider a number of other factors, including the impact of child support awards on low-impact families. So sometimes clients kind of question, why do I need to pay child support? And these are the reasons. It's because the state doesn't want to be burdened with the cost of raising the child. Now, Maryland has a child support advisory committee that's comprised of members of the General Assembly, the judiciary, child support administration, nonprofits, social workers, and attorneys. And actually most recently, or not most recently, but in 2020, the child support guidelines underwent a major overhaul. I'm sure a number of us are familiar with that, but prior to October of 2020, the shared custody calculation was anything greater than or equal to 120 overnights a year, or 35%. And this actually caused a lot of litigation over that threshold, over that additional one overnight, because it essentially had this cliff effect where the child support guidelines had a disparity between sole custody amounts and shared custody amounts based on that differential of 128 overnights a year. So in October of 2020, the guidelines were updated such that the definition of shared physical custody actually changed to 25% or 92 overnights a year. They also provided for an adjustment to the amount of support for the lower range from 25% to 30% overnights to eliminate that cliff effect that I was just talking about, the differential between the shared custody and the sole custody guidelines. The amount of overnights is now gradually increases rather than you see a shift of a substantial amount of increased child support for each additional overnight. They tried to eliminate that disparity. So it's now more of a slope increase than a cliff drop off. Now you don't really need to worry about the exact calculations yourself, provided that you use some sort of child support guidelines calculator. Again, we've talked pretty extensively about SASSY Calc, which is the programs that the court uses as well. And it does all of the calculations for you. So with that program, you really need only plug in the number of income for each party, or the amount of income for each party, the number of overnights, number of children, and any other credits, which we will talk about momentarily. Now, you shouldn't really run into this now, but I will just point out that the date of filing does matter. So if your request for child support or modification for child support was filed before July 1st of 2022, or by some chance of before October of 2020, the old law actually still applies. So the child support guidelines were adjusted in October of 2020. They were updated again in July of 2022. So that is to say that the current guidelines in effect are those effective as of July 1st of 2022. If you have a complaint or modification hanging out there prior to that time, that was filed prior to that time, you do need to use and make sure that you are using the appropriate guidelines for that period of time. I actually just had this in a case not too long ago where we had to submit 3 separate child support guidelines for 3 separate periods. We had to calculate the guidelines up until October 1st of 2020. We had to calculate the guidelines from October 1st of 2020 to July 1st of 2022, and then from July 1st of 2022 going forward. The other thing that the guidelines have been revised to do is they now range from $0 to now $30,000 a month in combined income. So for combined incomes beyond $30,000 a month, courts actually have discretion to set the amount of child support, though most judges will implement the extrapolated guidelines. And SASE Calc actually will do that for you. It'll just extrapolate the guidelines based on the amount of income, even if it is beyond that $30,000 in combined income a month. Prior to July 1st of 2022, the child support combined income was only $15,000 in combined income per month, and anything beyond that was discretionary. So this is a pretty significant change to the child support guidelines as of July of 22. Now, for your clients, you should know that there is also now built into the child support guidelines a self-support reserve, and that essentially ensures that the obligor is able to still maintain an amount of monthly income after the payment of child support and taxes of at least 110% of the federal poverty level for 2019. And currently that is $11.45 a month. If an obligor is left with less than that amount, there is a statutory basis for the court to now consider a downward deviation of that support. That is in Family Law 12202. Court
There's
also,
I'm sorry.
Yep.
Go ahead, Shannon. I'm sorry.
No, say. The court also now may enter a child support award of $0 per month if the obligor shows that they live with the child and contributes to the financial support of the child. Also, if they lack the financial resources to pay, you usually see these in cases where the parent is institutionalized or incarcerated, permanently or totally disabled with no income other than Social Security benefits, or they are hospitalized or obtaining drug treatment. So the court, again, may have the discretion to set the child support amount at $0 in those cases.
I just want to add here, this is a great example of the difference one person can make. So the person who for 30 years advocated for a change to the law has now passed away. I served with her on the Baltimore County Pro Bono Committee, 30 years ago, and she was an advocate for the incarcerated and for providing legal services incarcerated. In particular, there were usually fathers who got out of jail, and because they didn't have the wherewithal and there was some child support order entered against them before they went into jail, would get out after, say, a 5-year jail sentence and owe 60 months, and let's say it was $500 a month, would suddenly owe the crushing amount of $30,000. So after they got out of jail, there would then be a revolving door of contempt cases against them. And it was brutal. And it was not just that woman, but finally she was joined by Legal Aid. I believe MVLS weighed in on it. You know, all of the agencies that serve people who are low income. And it's not just now incarcerated, it's unemployed and institutionalized. And, you know I used to watch the criminal non-support docket some days when I had something else going on. And, these 20 guys would be brought in chains and would owe extraordinary amounts of child support that there wasn't the remotest chance they were ever going to pay in their lifetime. So anyway, so that was really one person who managed to do all that. and who led the way. It was really quite remarkable.
Yeah, I mean, that's exactly right. It really can be debilitating for some individuals in those circumstances. So we did talk about the formula, the amount of income, combined income of the parents, the amount of overnights and any offsets or credits. So what is the amount of income? Well, the amount of income is the calculation of actual monthly income from all sources. And that is actually defined by the family law article in 12202. And the legislature has found or determined that actual income means any income from all sources, including self-employment, rent, royalties, businesses, joint ownership of any partnership. And it does mean gross income. So gross income minus ordinary expenses required to actually produce that income. So what does that include? It includes salaries, wages, commissions, bonuses, dividend and pension income, interest income, trust income, annuity income, includes Social Security benefits, workers' comp benefits, unemployment insurance benefits, disability insurance benefits. For the obligor, any third-party payments paid to for a minor child as a result of the obligor's disability, retirement, or any other claim. So any money that the child is receiving on behalf of the obligor parent. Alimony or maintenance received is also included. And expense reimbursements, in-kind payments received by a parent for employment, self-employment, or operation of a business. And that is based on the circumstances of any particular case. The court may also consider as actual income severance pay, capital gains, gifts, or prizes. So if you go out and you win the lottery or someone gifts you, a couple $100,000, that's going to be included in your actual income. Actual income will not include benefits received by means-tested public assistance programs, including temporary cash assistance, SSI, food stamps, or any other emergency medical or housing assistance payments. So all of those would not be included in the calculation of actual income. Everything else is fair game, and that is divided on a monthly basis. So if you are receiving, a semi-annual gift of a couple $100 a year, that's going to be broken down into your monthly income in accordance with everything else that you're receiving as well.
There's one other thing that's not included, that's not in the statute, but it's covered by a case, which is if I'm disabled and I'm getting Social Security disability income rather than supplemental security income, the amount that I receive for the child is not included in my income. The other spouse does not get any credit for that in any way. So that arises out of a case where the judge gave the husband a set-off for the benefit that the wife was receiving for the children, and the appellate court said, no, that's the wife's money, period. So,
Yeah, and I actually just had that come up in a case recently as well.
Yeah, it's not specifically listed, but it's Live v. Foreman is the case.
So I already mentioned that the court will consider alimony or any other support received by the parties in the calculation of actual income. But that is also subtracted from the other party paying that amount of alimony in the child support guidelines as well. So if the court is awarding $500 a month in alimony, that's going to be added to one party and subtracted by the other party in the amount of monthly income. Now, when we're talking about income, we also need to consider that the court can impute potential income to a party, but the court does have to consider certain factors. Potential income is any income that can be attributed to a parent by determining, the parent's employment potential or probable earnings based on their background. So the parent's age, physical and behavioral conditions, their educational background. You know, if they have a PhD and they're not working, the court can determine that they do have potential to earn income and can use that for purposes of child support guidelines. If they have any special training or skills, how literate they may be, where they reside, occupational qualifications and job skills. Again, you know, if you have someone that has been in the workforce for a significant period of time and is not working for whatever reason, the court does have the ability to impute potential income to the party. The court will also consider employment and earnings history and any efforts that the party has taken to obtain or retain employment. We'll also consider any barriers or bars to employment, such as a criminal record, as well as any opportunities that an individual may have in their community. What is the status of the job market? Is it such that no one in that area of skill of that parent is able to find employment? What are the earning levels of the type of background that the person would be qualified for? And whether or not there is or there are sufficient employers willing to hire that person. We'll also consider current assets that the party may have, actual income from all other sources, and any other factor, kind of the catch-all, bearing on the parent's ability to pay or obtain support for their child. And all of those factors are set forth in the family law article, section 12, specifically 12201. Now, when we are talking about potential income or imputing potential income to a party, there are certain circumstances where the court cannot impute income. And that is when the parent is unable to work because of a physical or mental disability, if they are caring for a child under the age of 2, for whom the parents are jointly responsible. So that is everything that kind of goes into the amount of income. Again, if the court determines that they are going to impute income, that is the amount that would be calculated based on the child support guidelines for the amount of imputed income versus the amount of actual income that the other party is earning.
Let me just add here about the voluntary impoverishment, because there's a disparity between what the appellate courts say about that and what the trial judges actually do in most cases. So if you read every appellate case on voluntary impoverishment, and it's now been codified in the definitions, voluntary impoverishment is a deliberate and conscious decision not to earn income. So that's actually quite difficult to prove in reality. The fact of the matter is that most judges take a more liberal view of what constitutes voluntary impoverishment, particularly during a time of very full employment like we have now. You know, so if a person isn't disabled, you know, why aren't they working? Well, you know, there are all kinds of barriers to being employed when you're working with lower income people. And so you may find yourself defending someone with regard to child support. And so you want to be you want to be sort of conscious of the fact that judges often overstep on this issue in terms of finding voluntary impoverishment. Because, you know, you may not be able to quote unquote prove your client is disabled, but the other side is actually supposed to prove that your client is deliberately not employed so they don't have to pay child support. I actually kind of think what the judges do sometimes is more appropriate, but the case law is very strict against a finding of voluntary impoverishment. And that goes to a question that was asked earlier that's already sort of off my page, but I think we'll come back to it at the end.
Yeah, and that is exactly right. You know, sometimes courts really do jump at the opportunity to impute income to one parent when, you know, in a case that we had very recently, mom hasn't worked in, 20 plus years, had a college degree, and did fairly well for herself prior to having children. But after having children, they, decided that mom was going to be the stay-at-home mom and raise the kids. And she hadn't worked, for, like I said, 20 plus years. And notwithstanding, the court decided to impute income to her, finding that she was capable of working.
Right.
And that really just hasn't been the trend.
And I think that it was improper in that case was because mom was not voluntarily impoverished to avoid paying child support. Mom was not working because there was a severely disabled child at home. And I think that the judge got it wrong. So especially because it really made no difference to the ex-husband at all, who had quite a substantial income. It was almost silly.
So the other thing that goes into the child support guidelines is the number of overnights. The number of overnights is going to be based on the actual schedule of the parties. You basically just go through that and you count up the number of overnights a year. Anything 92 overnights and above will be considered shared custody, and anything less would be calculated under the sole custody guidelines. So 93 and up, you're talking about shared custody. Anything below that, we're talking about sole custody.
But again, as Shannon said earlier, the gradation now, they've gotten rid of the cliff. So when you go from 92 to 93 overnights, it's not as big a deal as it used to be. And then as you slowly increase the number of days, it's an appropriate gradation. It used to be a huge problem up until 20.
Right. You're not looking at that cliff where you may be paying $1,500 a month with 128 overnights, and you're paying $750 or something with one less additional overnight. So it's far more equitable, I would say, in terms of how that grade is increased. The other major thing that you need to be aware of in calculating child support guidelines is the offset for any other monthly expenses and or credits. So we're talking about extraordinary medical expenses. And that has been defined by the statute as any uninsured costs in excess of $250 in any particular calendar year. And that would be for any expense that both parties would be jointly liable for. That includes uninsured costs, orthodontia, dental, vision care, therapy, whether that is mental health therapy, whether that's physical therapy, any other professional counseling, psychiatric treatment, or any other treatment for mental health disorders. The parties are also entitled to offset the cost of any health insurance premiums that they pay for the child. Now, in doing that, oftentimes the responsible party is paying for the family coverage. So you would have to go through and extrapolate what is for the party and what is for the child. And that's fairly fairly easy to do. You just need to make sure that you get the medical insurance.
Rate sheet.
Yes, thank you, the rate sheet. And that is also inclusive of medical, dental, vision, any prescription drug coverage, things like that. The other few expenses that parties can offset are childcare expenses that are incurred due to employment. So talking about daycare, any aftercare programs, things of that nature. Those are by statute determined by actual family experience. So if the history shows that the child has been attending daycare because mom or dad is working and they cannot pick up the child due to the constraints of their employment, then that would be considered. If there is no history of any daycare or aftercare expenses, then the court can determine based on what is required to provide care from any other licensed source, such as a daycare after school care program. If the party chooses a daycare or aftercare program with an actual cost less than the level required to provide the appropriate care, then the court can consider the actual cost of what a appropriate childcare expense cost would be. So that would be if, you just have a friend or a neighbor that you're paying, every hour for childcare, the court can consider the cost of what an actual daycare would be. And the court can also consider an increase in those expenses if the child has special needs. So in the instance where childcare would be more expensive based on the needs of the child, the court can use those amounts as well. Court can also offset, that's really about it. There is a transportation expense that the court can offset as well. I don't think that there's actually a line item in SASE Calc for that, but there is kind of a catch-all that says additional expenses, and that oftentimes is used for any transportation expenses or any other catch-all extrapolated on a monthly basis. And any transportation expenses would be such that travel back and forth for if the child is in some specialty school, and or sometimes travel between the parents for custody access transfers. Now, as far as the calculations of the guidelines, especially using SASE Calc, there is one discrepancy that you do need to be aware of and careful of. So when determining the formula in doing these calculations, the child support for sole custody can actually be lower than it is for shared custody. And this tends to happen when there is a large disparity between the parties' incomes. Now, you may see when you are running the shared custody guidelines on SASE Calc, that it actually gives you a warning message that the shared custody guidelines are actually higher than the sole custody guidelines. And you are actually supposed to then use the lower sole custody guidelines rather than the higher shared custody guidelines. So again, when you're imputing all of this information in SASE Calc, you should get this warning message that says something along the lines of, warning, this amount exceeds the amount of child support calculated under the sole custody guidelines. So in that case, you need to switch to the sole custody guidelines, run the child support under those, under that formula, and then use the sole custody guidelines amount for the amount of child support.
And that's just one click on SESI-Calc.
Yeah, it's very quite simple. And that is what is referred to as the cross-credit approach, where the support owed in a shared custody case can never exceed the amount that would be owed in a sole custody scenario. I don't think that we can stress this enough, but SESI-Calc really is your best friend. The courts use it. It's very helpful if you are familiar with the program, if you are familiar with the guidelines that the courts use, that you're using. They spit out the exact same format. It's quite easy to read. And as far as any deviations from the child support guidelines, I think we touched on that, briefly, but courts do have the ability to deviate from the guidelines if they are above the $30,000 combined income threshold. And then if, again, there is a party that does not earn a substantial amount to be able to cover the cost of child support if that child is residing with that parent. Sometimes you'll see the court deviate from the child support guidelines in other cases, but it's rare, and they really generally do try to stick to the guidelines as best as they can, because again, they are presumed to be correct and accurate in these particular case within those particular factors.
So one of the questions that comes up with that issue of deviations is there are times when the only way you can get a case settled is to do a downward deviation from the guidelines. Now, I'm personally always very reluctant to do that. I'm really kind of a purist about guidelines. I think it's for the children. I don't like it when people ask my client to do that. And I don't like it very much when my own clients ask to, pay less as part of a settlement. Plus, there is a case, oh my God, I'm totally blanking on this, that says courts cannot deviate from the guidelines unless they really have a substantial reason for doing so. A lot of judges really take that seriously, and even if you're doing a settlement, won't do it. I think these days most judges will, but if you're in a trial with a magistrate on child support or with a judge, you better have a really good reason for deviating downward from the guidelines. It's incredibly unusual. I actually can't think of a time when a court did it. The most offensive thing I had recently was a guy who was a high-ranking police officer who didn't pay a penny of alimony or child support to his stay-at-home mother wife, and, goes into the trial arguing that, well, the court has the authority to do a downward deviation because now, since he hasn't paid, it'd be a real hardship for him to pay the $40,000 he should have paid. And I mean, I was just like, you got to be kidding. Too bad. You shouldn't have been such a jerk. I don't think that was the word I was thinking at the time. I, for one, don't like downward deviations. I think they're inappropriate. And I can't think of too many circumstances where it's actually really justified. I've had people where there were like 5 kids and the child support was something like, 40% of their net. Well, guess what? Shouldn't have had 5 kids. You got to support them. I'm not going to feel sorry for you. And neither will the judges for the most part. So.
And that's another conversation that oftentimes we are having with clients is, well, then I won't seek child support, or I don't want to pay child support. And again, it's a reframing of the issue is it's not the parent's obligation to either pay or receive that child support, it really is the right of the child. So the parents don't have the ability to waive child support on behalf of the child. So again, when we're talking about kind of a downward deviation from the child support guidelines, or sometimes you'll see like a general charge of child support, each parent will be responsible for the payment of the child's expenses generally. What Jack's referring to is courts don't often like to do that because, again, it's the right of the child. It's not the right of the parents to either pay and or receive that amount of child support. Some parties think that it's a bargaining chip, particularly, if you're representing a party that is seeking more access or custody, they're saying, well, if they'll give me more access, then I won't pursue them for child support. And again, it's just having that conversation with them that you may not wish to seek child support. That may be something that you're offering, but you really don't have the authority to offer that because it's not your right to receive and or pay. If you're on the other side, it's the right of the child.
And this is one of those rare areas these days where I still see real differences between men and women. In 30 plus years, I've never had a woman come into my office and say she didn't want child support if she got custody. I still often see men who come into my office and say, well, I'm the one with custody, but I don't want any support from her. I can't think of a time I've heard a woman say that, but you hear men say that. Still one of those rare differences that you see. I don't know why they ought to get the child support if it's a guy get him with custody, but it's what it is. All right. Okay. One other thing about child support formulas, yes, Sassy Calc really is the way to go. It's fairly inexpensive. There is a DHR website, but be careful with it because at certain upper income levels, they haven't corrected their programming to some of the changes made in 2020, at least a year ago when I last checked. And I tried to find out now, no, I don't have a response yet, whether or not that's been fixed by DHR. But for a period of time, it wasn't 100% accurate on that. It also doesn't give you the warning message about the discrepancy between the sole custody and shared custody when it ends up being more for the shared. So you do have to pay attention. One good way to learn how these formulas work, by the way, is 2 or 3 times when you've got a case, do it by hand, right? The worksheets in the statute, do it by hand. It's a really good educational process. When I started practicing, there was no software for it. And you always had to do it by hand. And, you and the other lawyer and the judge would literally sit there in the courtroom, making sure everyone's math was correct. You don't have to do that now, but it is a good way to learn. And it's how I learned. And, sometimes the interrelationship between income percentages, expense percentages can get a little daunting when you're trying to explain it to the client if you've just used the computer. So you really want to make sure you understand exactly how those formulas work. So, okay. There were a couple questions here. So there was one about voluntary impoverishment. Well, I'll answer that one about what happens after multiple contempts. I mean, eventually after the second or third time, a judge should get tired of it. But the problem is that Maryland has so effectively gutted the court's ability to jail for contempt that unless someone walks into the courtroom and says, Judge, you can't make me pay child support, sometimes there's really not much they can do about it. I had my first case in, 15 years. It was a custody case with access denial, where the judge actually had grounds to sentence the person to 6 months incarceration, and then they suspended the sentence based on future compliance with the court order for a 4-month period. In other words, the purge provision. But other than that case, I can't remember the last time a judge ordered someone to jail. And was actually the first time the woman ever obeyed the custody order in like 3 years. And she eventually lost custody because she was doing that. But it took a while. So, and it's Jillian, I just wish I had a better answer for you. The fact of the matter is that I think the legislature really needs to give the court more authority. I actually think the Supreme Court could change the rules that apply to contempt that are in Title 15. And I don't know why they don't. There's also criminal contempt of court for which you can go to jail. The problem is under our statute, a criminal contempt case has to be referred by a judge to the state's attorney, and the state's attorneys for the counties just aren't interested. They're just not going to do it. So it's a problem. It's a part of the law that Maryland is just completely ineffective, and it's just wrong. So, and there's a question from Kathleen. Kathleen, I'm not sure I understand your question. How does paying, oh, that one I know. There was one earlier. I'm sorry. So that question's easy. The court has discretion when there's use and possession to lower child support. So if you're paying $1,000 a month for the mortgage, usually the court will give some credit on child support for that. It's in the statute, although I couldn't tell you where right away that it is. What I will usually do is I will usually slip that use and possession payment in under alimony as if it were alimony, and have that sort of be money received by the other party, or at least half the mortgage payment as a form of alimony, and reduce the child support that way. I think that's a reasonable method. All right. Was the question above I didn't answer?
There's another question of why does the entire mortgage payment get deducted from gross rent proceeds?
Oh, yeah.
And some of the mortgage goes to principal purchase of the property.
For what, Geraldine, can you just type in when it gets deducted from gross rent? I'm not sure what, I understand what you mean. From where? For child support calculation or for determining the marital property division? Oh, for child support. Just because it's discretionary. That's sort of the same question that Kathleen asked. I think every judge sort of has a different way of doing it. And you probably will see some use and possession cases when you're doing MVLS cases every once in a while. So I just think the judge is going to give some credit for it, and it'll just be their best judgment, what they think is fair. Same with the magistrates. But you know, in the city, you're not going to see that too often. I had a marital property case in front of Judge DiPietro last month, and he commented that it was the first marital property case he'd seen in a year, because they usually settle. And in a city, they have so many low-income people in court, they usually don't see marital property. Also, if you're trying a marital property case and there are no custody issues, it's either because one of the lawyers is crazy or one of the parties is crazy. In this case, it was both the lawyer and the party on the other side were just off the wall. And they threw in the towel after they realized it wasn't going well for them. So, okay. So I thought we're done a little bit early. Any other questions?
Did we get to all of the questions? Does anyone have any other questions they would like to post? Certainly can send questions to me after if you think of some that post session that you would like to ask, and I will make sure that they get to those our panelists for their answers. And I also want to just bring say a couple of things before we close. As I mentioned early on, that I will be sending out the materials in the next few days, and you will be receiving last session and this session materials and videos, and I will post them and also send them directly to the attendees. I also wanted to just mention to all of you who are on this webinar, just to refresh your memory, I see some names I don't recognize that are not members of the Judicare panel. And if you are interested in becoming a member, please contact me. The Judicare panel is, for those who don't know, is a group of attorneys who have at least 3 years of contested custody and divorce experience, or have had 2 years of experience being mentored by a identified Judicare panel attorney. And if you fit into those categories, you certainly are welcome to contact me, and I'd be very happy, if you're interested, to place you on the panel. These attorneys are compensated for a total of $4,200 per case. And we're always in need for new, fresh minds and people who are really interested in giving back to these clients who are in most need and most vulnerable and lack, frankly, legal services, competent legal services. So if you're interested, please contact me directly, and I will be more than happy to add you to the panel, provided you meet those qualifications. If anyone, lastly, but not least, I'd like to thank both panel members again. This was a tremendous program. I received many, many comments about how wonderful it was for the attendees in terms of how they can proceed and work through their practice with the materials you have given them. And I personally cannot thank you enough for being a part of our webinar series. We really appreciated it at MVLS, and I do as well. So if there are no other questions at all, then we will end the presentation, and we will see each other soon.
Oh, someone just asked you a question in the Q&A about whether the fee is a fee.
Let me see. Let me see here. I don't see it. Could you read it to me, Jack?
Sure. The question is the $4,200 a flat fee, or is it the maximum amount that can be paid?
The $4,200 is the maximum amount that can be paid. How it is usually done is you can bill your hours twice during the time you have, 2 or 3 times. It doesn't really matter how often you bill us for the amount of time. However, it is $120 per attorney time per hour and $40 for support staff per hour, up to an amount of $4,200 per case. Now, some of our cases go a little longer than that. Some of our cases take more time. And as a result, what we request of our attorneys is, once they've reached that maximum of $4,200 that has been billed, then the remainder of the case would be, you would be continuing with that pro bono without compensation at that point. So it is a $4,200 amount. You don't always necessarily use that total amount each time. It's the amount that you use for that case. If it closes early, it will be the amount. Maybe not $4,200. If it closes late, you'll get the max of $4,200 per case, and the rest would be considered a pro bono matter. Does that make sense? Okay. All right. So without any other questions, we will end our program, and thank you to everyone attending and our panelists, and we will talk soon.
Right. Thank you, Nancy.
All right.
Thank you.
Bye-bye.
All right, bye-bye.
Bye.